Good morning. This is the Energy and Carbon Management Commission. It is Wednesday, December 11th, 9 a.m. We have a business agenda before us, and we will start with a roll call.
Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner Messner.
Here.
Commissioner Oath.
Here.
Commissioner Ray. Commissioner Robbins.
Here.
Mr. Chair, you have 6 commissioners present.
Great. Great to see everybody. Welcome to our meeting today. We have a few matters on the agenda. First is commissioner comments. This is the opportunity if any commissioner has comments for the rest of the commission and or our stakeholders to speak up. Seeing no comments, we move to public comment. Hearings Manager Thomas, I don't know if we have the one person that signed up. The name was Nick Charchalis, something like that. Do you see him in the meeting?
We currently do not see him in the attendee list, Mr. Chair. If Mr. Charchalis is in the attendee list, if you could raise your hand, we'll promote you for your public comment. Otherwise, I believe we found him. One moment, please.
Okay.
All right, Mr. Charchalis, looks like you've unmuted.
Okay, there we go. Yeah, it's nice to be, sorry for my voice today. I kind of got a crackly voice. It's kind of a seasonal thing here, I think. Anyway, just a few brief comments. Just wanted to make the commission
I'm not hearing Mr. Charchalis. Is that just me or are others able to hear him?
It looks like he froze, Mr. Chair. I'm not sure you want to proceed if we want to give him a minute and see if his Zoom resets.
Yeah. Now he has left the meeting as best I can tell. Is that right?
Yeah. We will see if he rejoins.
All right. While we're waiting on that, we have a consent agenda before us. Does any commissioner have questions with regard to consent? Seeing no questions, I would move approval of consent. Do we have a second?
Second.
Motion and a second. Further discussion on consent? Seeing none, all those in favor of consent signify by saying aye. Aye. All right, consent agenda is approved. We have accomplished something. Hearings Manager Thomas, what's your, oh, there we go. I think we've got him back.
Not sure what happened there, guys. Sorry.
Go ahead. We can hear you and see you.
All right, I will. Anyway, we're ranchers out here at South of Craig, and PLC1 is a oil gas operator on the property we have. Has been for a while. They are, as you may know, probably been and still the subject of ECMC enforcement, and it's been a while. They are purportedly in the process of cleaning up this significant contamination on our ranch property that's been there and been an issue for a long time. But it has been right about 2 years now since they were shut down by your commission, and for good reason. There were always spills. There were always things that I went along with it because they provided a lot of water. It was warm water out of the processes. Wasn't that bad most of the time, but every now and then it just got really bad. So anyway, it needed to be cleaned up, but it's been 2 years and we haven't seen a completion. Some progress, but not significant progress. It's been slow walked, pretty much. This year they were supposed to show up in May, And then they showed up in September, and now it's all frozen, and they're just beating themselves up trying to get it done. Um, so that's a couple of years out on that deal, and not a lot of well, it's not completed by any means. So Wayne Newmiller is the principal of PLC. I understand he's involved in other individuals involved in some other stuff around the state or in Wyoming. I don't know. Anyway, so in the past year, one of PLC's contractors put a lien on our property, a substantial lien, because PLC had not paid them and for the work that they did. Now they both of those entities called and said, "Oh, Nick, we tried, we did this, we did that," but the lien still remains, and it's a really big burden on us. We're ranchers, we don't have an oil field, we don't get monthly income, we don't. It's a real burden. We have now been embroiled in this litigation, and we've already spent almost $100,000 in legal fees that haven't. I mean, we didn't do anything. We sat there. We were the owners, happy to get somebody to clean it up, and then we got into this mess. So, and we're still there. We're just still there. So you understand kind of some frustration here. Then there's got to be an end to it, and that's kind of a plea to your commission to kind of look into this a little better. Now we've talked, and everybody always says, "Well, that's a civil matter." Well, it's more than a civil matter. So, so today we have a polluted mess on our property still, and we could even lose it. Liens are that way; they could foreclose on our property, and that would be pretty devastating. Worked pretty hard to pay it off over the years, and they haven't paid just because they don't want to pay. Apparently, I don't know why they're not paying them. They should, and it's somebody they hired. We have never hired anyone to clean up that mess. There was some ancillary stuff we did years ago with a bulldozer getting some concrete out of the way on our own, but nothing to do with this oil field. So, at one point they even had, PLC even had the audacity to kind of recommend that we pay the bill so that we could get out of the legal case. So, it's reached some new lows there. There's I think there's a better time today. I just wanted to put this out there and try to bring it to the surface and possibly talk about it at a future time when we're on the docket. We can be prepared and I have a voice that would help too. But I felt like the commission needed to know that this is happening in Colorado. And there were operators like PLC and Wayne Newmiller out there, and they're not being held accountable. They're just not. They're able to do all the things that they've done to us. So really, that's all I wanted to say. I guess if we have 5 minutes, I don't know if you guys have any questions or not. I'd be happy to answer them. But I would like to maybe set up a time down the road to discuss this matter further. So. Thank you for your time this morning.
Okay, thank you very much for being with us. I will ensure that the appropriate enforcement officer sets up a time to talk to you further about whatever the problems are, the issues that you are raising. So plan on somebody getting in touch with you. I can't promise what that outcome would be, but we can make sure that there is at least coordination and communication. Fair enough?
Yeah, and that's great. I appreciate it. And just to know that you guys are basically the only hope that we have. CDPHE can't do anything. BLM can't do anything. State of Colorado can't do anything. Every agency I've contacted said, it's in the hands of ECMC. So you'll have to go to them. Here I am. So very good. Thank you. Let me know. And I do like your people. I've talked to a couple of them, a couple of your representatives, and your guys, your engineers out here, and they're good.
Yeah,
so I appreciate that.
If you could reach out to me with your contact information, maybe a phone number or an email address. My email is jeff.robbins@state.co.us. So if you just give me that contact, and I'll make sure someone gets in touch.
Okay. Thank you, everybody. I'm sorry.
We do have your contact information, so we will reach out as well.
There we go. All right.
Well, I
thank you very
appreciate your time. Great holidays.
Have good
you
holidays.
later.
Stay warm.
Bye.
All right. We now will turn to order number 535827. This is a PDC Pierce URU annual update. And I believe we're going to elevate either Ms. Jost or Ms. Weslinki. Good morning.
Good morning. We've got a few panelists. So it looks like they're still being admitted. Chair, would you like to swear everyone in for this update?
AG Davenport, what's your druthers?
I'm happy to go ahead and do it.
Okay.
Do we have many folks to swear in?
We have 4. There should be a Mr. Tony Williams, Mike Marini, Tyler Sims, and Brian DeRose. So it looks like we've
do
got...
see everyone.
Correct.
Okay, thank you. I believe all of you may have been through this process before. I'm going to ask you to, in turn, to raise your right hand, state your name, and that you swear to tell the truth. We'll start with you, please, Mr. Marini.
Hi, I'm Mike Marini, and I swear to tell the truth.
Thank you, Mr. Williams. I'm not getting audio from you. I did see you unmuted, but it doesn't appear to be. We will, okay. Mr. DeRose.
Brian DeRose, I swear to tell the truth.
Thank you. Mr. Sims. I didn't get any audio from Mr. Sims.
And Mr. Davenport, Mr. Sims should not... Oh, did we just hear you?
Would you say it again, please, Mr. Sims?
Tyler Sims, I swear to tell the truth.
Thank you. All right. Thank you all.
And Mr. Williams will have a presenting role. And so perhaps...
Folks, can you hear me?
Yes.
Here we go. Okay.
Can you see me?
No.
I apologize.
That's okay.
I am Tony Williams, and I swear to tell the truth. Looks like I'm here now.
Thank you.
Wonderful. Thank you. We do have a PowerPoint. If we could just pull that up, and we're happy to get started. Okay. Well, good morning, commissioners. My name is Kelsey Wazelinki with Jost Energy Law. And with Jamie Jost, we represent PDC Energy in the Pierce Unconventional Resource Unit, or URU, before you today for an annual review. The last annual review for the Pierce URU was almost exactly 1 year ago, and we appreciate your time this morning to present a few quick updates on the Pierce URU development. Next slide. I'll provide a brief overview of the Pierce URU before the PDC team provides an update on the URU development. The Pierce URU Order 535-827 requires that the URU be set for review by the Commission annually, and notably, no action is required by the Commission today as part of this review. The approximate 4,800-acre Pierce URU was established by Great Western Operating Company on June 12th of 2017. Great Western had been providing annual updates to the Commission through 2021, and PDC gave its first update in 2022 after acquiring the assets of Great Western. Next slide. We presented this slide last year from a 2021 staff presentation on URUs, and we thought it would be a helpful refresher. URUs have been recognized as an important tool by the ECMC and are focused on downhole mineral development to protect mineral owners. The URUs that have been formed in Colorado were established primarily to protect mineral owners in the development of unconventional reservoirs and to provide flexibility to operators to develop a resource as the operator's technical understanding of the subsurface resource grows. To this end, the Pierce URU order allows for the appropriate number of horizontal wells to effectively and efficiently drain the reservoir. A URU can be considered a hybrid between a drilling and spacing unit and a state unit, and the Pierce URU order does provide that the URU will be governed by a unit agreement and a unit operating agreement. Next slide. As more background, PDC owns approximately 88.2% working interest in the URU, and two of the larger leasehold owners have provided letters of support for the URU development. And as I previously mentioned, the Pierce URU is governed by a unit agreement and a unit operator agreement. Next slide. This map shows the PDC leasehold within the URU in yellow, and the two drilled URU wells drilled from a north to south orientation from the existing Riemann pad. I do want to take a minute here to address a question that came up last year during our annual review regarding any updates or change in surrounding surface land use or future uses being contemplated that may be affected by the URU. The existing Riemann location continues to be zoned agricultural. As PDC will discuss next, PDC is considering consolidating future TNM wells onto the existing Riemann location. PDC is also considering a new location in the northeast of the URU, which is currently zoned ag, and a new location in the southeast of the URU, which is also zoned ag. This is a rural area with minimal residences or surface development, and PDC is not aware of any future planned development around the existing and future locations, nor any changes to this surrounding land use. Next slide. This is a summary of the Pierce URU timeline. The first URU well was spud and completed by Great Western in 2019, and gas takeaway was also established in 2019. The second URU well was spud and completed by Great Western in 2021. PDC acquired the assets of Great Western in 2022 and proceeded to file 4 new Riemann APDs for additional north to south development of the Pierce URU from the existing Riemann pad. Chevron acquired PDC in 2023, and the 4 Riemann APDs were approved in November of 2023. I'll now pass the presentation over to Tony Williams to discuss the future development planning and geology.
Good morning, commissioners. Can you hear me? All right, great. I'm planning the Pierce Unconventional Resource Unit, like other development areas in the or other planned developments, requires a geologic robust review to look at the to access the resources. What you're seeing here on the right is a structure map of the top of the Niobrara. Draw your eyes or your attention to the dashed line from the bottom left to the top right. That represents a structural complex area. That is a fault complex with approximately 150 feet of offset. That's a large offset or a large set of relief. Oftentimes we plan our wells around these. This represents what we do in most fields and most places across the basin. We plan our wells not to cross.
Mr. Williams, I'm sorry, we may have lost your audio.
Can you hear me again?
Yes, we can now, but you were cut off.
That was magic. I don't know what's going on. I'm sorry, guys. But you can also see that we plan our wells not across faults like that. This is consistent to drilling and completion capabilities that we have in the basin. The image you see here, as Kelsey said before, this is from our 2023 annual review. It shows our geometry of our well bores, but it also shows what we presented last year. This year, we've reviewed this again, and we think we can reduce the number of wells, and we can also consolidate locations. To talk about that, I'd like to pass this on to Mike Marini on the next slide.
Great, thanks, Tony. Good morning, commissioners. My name is Mike Marini, and I'm a reservoir engineer here with Chevron. Chevron purchased this asset along with PDC in 2023, and we've maintained a high level of interest in furthering development here. In fact, in 2024, we dedicated a full-time staffer to conduct a subsurface study and determine an optimized plan of development, given how different this area is subsurface-wise compared to the rest of Corwell County Niobrara acreage we're all used to looking at. If you compare the recently updated map on this slide versus the previous slide that my colleague Tony Williams presented, you can see our latest plans now have fewer wells coming from fewer pads. To further our subsurface understanding, we are also taking advantage of new data in the area. In mid-2023, Bayswater began producing the Topaz wells, which are adjacent to the Pierce unit, and were drilled and completed at a variety of benches, different well spacing, and with modern and enhanced completions. It takes about a year to be able to put a forecast on the well to predict production into the future, and in 2024, we had enough production data to do so. This new data has provided excellent learnings in contrast to the surrounding area that was mostly developed with standalone parent wells over the years. This internal study and the latest well results are helping Chevron dial in our subsurface plans to optimize the Pierce URU and ensure efficient development. We have also furthered our plans to optimize pad locations and where we choose to put surface. The URU was originally contemplated to allow for up to 6 pads within the unit. Based on recent improvements in technology in the DJ, the URU is now being optimized for larger step outs and potentially for U laterals. Because of this, we're currently progressing work to have the Riemann pad, which you can see on the map, pick up additional wells from the T&M pad, ultimately eliminating the need to drill any future wells from T&M. And we're working on acquiring a surface location in the northeast corner of the unit that picks up the balance of the wells in the northern row. For the southeastern row, only a single Owl Creek pad will be utilized. This will allow us to go from 6 pads to just 3. Any new APDs going forward would, of course, finish going through our planning process, and the commission will get to review all this at a future OGDP hearing. Last note, the Riemann APDs were approved in 2023. Those are the 4 permitted wells on the west side on the map with the green sticks. They do serve as potential test wells for Chevron. However, I want to be clear, we're making plans to develop this entire unit. We're going to use the pad savings. We're going to utilize the results of the subsurface study that we conducted this year. We're working towards a single shared facility for all these wells, and we're excited to move this project forward to full-scale development. Thank you for letting us update you on the Pierce unit plans. This concludes Chevron's presentation, and we're happy to take any questions you have.
Very good. Thank you for the update. Commissioners, the panel is open for questions. Well, you did a good job with your update. We have no questions. We will see you on December 11th of 2025.
Thank you.
All right. Commissioners, next on the agenda is a return to docket 241-000246, the Class 6 rulemaking. A couple of matters on the agenda for that. We do have a request to reopen the rulemaking record from CDPHE, that's the Colorado Department of Public Health and Environment, and CEO, that is the Colorado Energy Office. We also have a objection to that request by Wild Earth Guardians, Green Latinos, and 350 Colorado. We received last night a non-objection to the request to reopen the record. That was filed by CCS and the Colorado Chamber. And then the other matter on the agenda is to further deliberate, consider the red line edits that staff put together following direction from commission last week. I'll start with some thoughts about the request to reopen the record. I'm just one commissioner, but can kick it off with some deliberative thoughts on that. The matter to reopen the record is to allow CDPHE and CEO to give consideration to us on the issue of the carbon. Now I'm blanking it. Somebody help me.
Social cost of carbon.
That's it. I was going carbon capture and sequestration. It's a long morning. I think that's an important topic. At this point, it is not in our rules. It is, however, referenced in the statement of basis and purpose. I would be inclined to reopen the record and allow our sister agencies, who we do appreciate their perspective, to provide some perspective to us on that. I would suggest we perhaps reopen the record, allow them to come in and talk to us about their perspective on social cost of carbon, And then I would hold off on making a determination on what we might do next in terms of the idea from CCS and the chamber, who wanted a few days and a few pages to speak to this, versus Wild Earth Guardians, Green Latinos, and 350 Colorado, who wanted a day to think about it and then come back with oral statements on it. I don't know exactly which way to go on in either of those. I think a lot of that has to do with what we might hear from CEO and CDPHE with regard to their thoughts on social cost of carbon. What do other commissioners think? Or put another way, does that sound okay? Commissioner Oath?
Yeah, thanks, Mr. Chair. I would agree. I think it would be very helpful to hear from the agencies on this issue. I know it was one specifically a question that we asked, and so any additional information or context, I would appreciate knowing.
Anything else from anybody? Commissioner Ackerman?
Yeah, thanks, Mr. Chair. I have no objection to what you've laid out. I would also note that we have reopened records in the past when new information has been desired to be presented. And so I think this would follow along with the way we've handled some hearings in the past.
Okay. AG Davenport, if you could visualize. Any concerns with the outlined plan of action with regard to this from the Administrative Procedures Act or otherwise from you as our lawyer?
No, Chair, as long as we have a full commission motion and approval to reopen the record, I don't have any concerns.
I would move to reopen the record as articulated by myself recently to hear from CDPHE and CEO.
Second.
Motion and a second. Further discussion? All those in favor signify by saying aye. Aye. Any opposed? All right, motion carries. Hearings Manager Thomas, how quickly do you believe you can elevate whomever it is that wants to speak to us now that the record is reopened?
We're in the process of elevating Clay Clark. He's rejoining now. He'll be giving the statement on behalf of the agencies.
Okay. And do we have our staff further impaneled now that the record is reopened?
We're doing that as well.
Okay. Because we may have questions of staff after we hear, so would like them to hear this as well. Mr. Clark, good morning.
Good morning, commissioners. And for those of you that don't know me, I am Clay Clark. I oversee the climate change program within the Air Pollution Control Division at CDPHE. On behalf of the Colorado Energy Office, CDPHE, and ECMC staff, we'd like to thank you for agreeing to reopen the record on this rulemaking and for the opportunity to speak to you today. We're here because we'd like to clarify what was intended, and perhaps more importantly, what was not intended with the information the Air Division provided regarding the social cost of carbon earlier in the hearing. By attempting to clarify that the social cost of carbon includes a broader range of benefits than purely community-level benefits, the Air Division did not intend or expect that the social cost of carbon would not be considered at all regarding proposed Class 6 injection projects. In fact, in the context of the work that we do at CDPHE, the State Air Act directs the Air Quality Control Commission, or AQCC, to consider the social cost of carbon in adopting any regulations to reduce greenhouse gas emissions. And the social cost of carbon has been specifically incorporated into AQCC regulations that apply to many of Colorado's industrial and manufacturing facilities. Statute also requires the use of the social cost of carbon by the Public Utilities Commission for utility regulation and by the Department of Transportation for use in cost-benefit analyses. Given that Senate Bill 2316 in directing ECMC to consider cumulative impacts for siting Class 6 wells defined such impacts to include effects on climate along with other impacts on health and the environment, we recommend ECMC also utilize the social cost of carbon in weighing the net benefits of Class 6 injection sites. The social cost of carbon measures the projected climate change damages to society caused by 1 additional ton of carbon dioxide emitted, or equivalently, the climate benefit to society of removing 1 ton of carbon dioxide. Because CO2 is a globally well-mixed gas, the impacts occur across the globe, and the social cost of carbon reflects these impacts. Because some of the benefits from a Class 6 well project will accrue outside the location of the project, failing to use the social cost of carbon would underestimate a proposed project's benefits to society and prevent a more complete accounting of a project's true impact. By statute and across multiple regulatory venues, Colorado uses the social cost of carbon that has been adopted by the federal government, with a caveat that the social cost of carbon used cannot go lower than that established in 2016 by the Federal Interagency Working Group on the Social Cost of Carbon. The social cost of carbon is the measure for understanding the net climate impacts of greenhouse gas management projects like carbon sequestration. The social cost of carbon remains the best quantitative tool available to estimate climate impacts on a project that produces or reduces greenhouse gas emissions, including carbon capture projects. We recognize that the cumulative impact analysis is a qualitative exercise reflecting the best judgment of ECMC commissioners across a wide variety of project benefits and harms, ranging from air quality, water quality, noise, odor, wildlife, and other considerations directed by Senate Bill 2316, as well as climate. We also recognize that this qualitative assessment can be informed by quantitative data. We recommend that rather than stating that the ECMC will not use the social cost of carbon in this determination, the statement of basis and purpose should state that the social cost of carbon should be one metric considered as part of a broader cumulative impact assessment. While the benefits of avoiding greenhouse gas emissions are diffuse, Colorado communities are feeling the impact of climate change through increased extreme weather, wildfire, higher levels of ozone, and other risks. Establishing a framework for safe and effective permitting of carbon capture technologies in Colorado is important not only on a project-by-project basis for the state to meet its statutory GHG reduction goals, but also for continued leadership in the region and the world in commercializing these solutions, which collectively are necessary to keep global climate change to a minimum and achieve net zero emissions by mid-century. Prohibiting the use of the social cost of carbon altogether ignores important considerations in developing a complete understanding of the potential cumulative impacts of projects in Colorado. To not consider the social cost of carbon is also inconsistent with underlying statute that defines cumulative impacts as including the impact of a project on the climate. It is essential for the Commission to include relevant information about the climate impacts of proposed projects in their analysis. When evaluating the cumulative impacts of any proposed project, many factors must be considered. In the case of a Class 6 well, the social cost of carbon is appropriately one of those factors. CDPHE and the Energy Office recognize it cannot be the only factor considered, especially at a local level. For example, if a project were to be proposed in a disproportionately impacted community and in close proximity to many of its residents, the social cost of carbon would not be the sole factor in making a decision that considers the risks and benefits to public health or the environment that the project poses to those specific residents. Given the value of the social cost of carbon in policy and regulatory decision-making in Colorado, CDPHE and the Energy Office recommend no changes to the revised regulatory languages published by ECMC staff on December 9th. That language allows the Commission to consider a variety of qualitative and quantitative information, including the social cost of carbon, in evaluating the cumulative impacts of a proposed project. However, we do recommend clarification in the statement of basis and purpose that the Commission can use the social cost of carbon when appropriate to evaluate the environmental impacts of a proposed Class 6 project. We hope this joint agency statement sheds some additional light on this complex topic to inform your deliberations in this rulemaking. We're now available to answer questions of the Commission.
Thank you, Mr. Clark. Appreciate the presentation. do the agencies have specific language that you would like us to consider in terms of the statement of basis and purpose?
Thank you for the question, Commissioner. I think where we've landed is that we, based on this recommendation, would leave it to the commission to craft that language, but based on the recommendations that we've provided here.
Okay, so we would, if we're interested in this, look to our staff to take your verbiage and turn it into SBP language. That would be your recommendation.
That would be our recommendation, Commissioner.
Ms. Sorensen has also visualized. Did you have anything to weigh in on that?
No, Mr. Chair. I think Clay actually summarized that really well.
Okay. All right. We're going to take this one step at a time. We have Mr. Clark, or Director Murphy's also visualized. Oh, now she's not, so she's gone. That's fine. We have Mr. Clark available for further questions before we proceed to next procedural steps.
Commissioner, if I could just point out also, I think, we also have Dr. Barnabas Wold, who is our economist that leads our work utilizing the social cost of carbon for the AQC regulatory developments that we do. And I think Director Tour is also with us as well. So I'm happy to answer questions, but I just want to make commissioners aware that there's other voices here that can be heard as well.
Great. With those comments in place, Commissioner Oath is recognized for questions.
Thanks, Mr. Chair, and thanks, Mr. Clark, for those comments. Very helpful. I think you did say in your remarks, maybe it wasn't specific recommended language, but it sounded fairly close to it. And I was wondering if you could read that part of your remarks or state that part of your remarks again, where you sort of said, instead of, stating such and such in your statement of basis and purpose, we'd recommend something more along these lines. Could you state that again?
Yeah, and let me ask a follow-up. It appears you were reading from something. If that is the case, we would probably like to have that submitted into the formal record so that we've got the written document ahead of us. Having said that, if you could confirm you could submit the written document and then also answer Commissioner O's questions, both would be appreciated.
Well, to answer the question, we certainly can provide the written statement that I've been reading from. Apologies that it was so obvious I was reading, but yes, I was reading from a written statement, and we'd be happy to provide that using whatever procedural vehicle is correct for this commission.
Okay. Then if you could read back into the record what you
certainly
read.
and I will read that section just for context around I think the specific language that Commissioner Oath was asking about. And that reads, given the value of the social cost of carbon in policy and regulatory decision-making in Colorado, CDPHE and the Energy Office recommend no changes to the revised regulatory language as published by ECMC staff on December 9th. That language allows the Commission to consider a variety of qualitative and quantitative information, including the social cost of carbon, in evaluating the cumulative impacts of a proposed project. However, we do recommend clarification in the statement of basis and purpose that the Commission can use the social cost of carbon, when appropriate, to evaluate the environmental impacts of a proposed Class 6 project.
Thanks for that. And then I guess I just want to make sure I understand that in the context of kind of the other written response to the question on this topic as well. So thinking about the two together, are you saying in your written materials, maybe you said it's important not to think about the social cost of carbon quantifying benefits precisely to a local community, but you're saying it is a tool that you can look kind of more globally at the benefits that that it would benefit society as a whole, including a local community. So you can't exclude the benefits to a local community, but it may be a bit of a qualitative application of the social cost of carbon since it's a sort of global number. Am I understanding that correctly?
For that question, Commissioner Oath, and the opportunity to explain that. So in answering the question was, as you say, regarding the ability to use the social cost of carbon as a tool to specifically identify impacts on a specific community. And what the division was really attempting to clarify in response to that question, but also some of the testimony was provided that was provided earlier in the hearing, is really that the social cost of carbon is not a tool or a model that can be dialed in on a case by case basis to specify an impact on a specific community. Really, the strength of the social cost of carbon is that it provides a vetted, standardized approach that can be objectively applied to determine the impacts on climate from a proposed project.
Okay, thank you.
Commissioner Messner.
Thanks, Mr. Clark, for being here. I think I'm struggling with this a little bit because my reading of statute, what I've applied here is that we're asked to apply a no net negative adverse cumulative impact standard to disproportionately impacted communities, right? So a finite community. And so and statute also clearly directs us that to evaluate environmental and public health implications to that finite community, the disproportionately impacted community, and does not call out economics as a consideration to that. And so help me understand how the social cost of carbon and looking at this from a global perspective helps us determine. I mean, we're not just determining cumulative impacts. That's a separate conversation. That's a separate set of rules that we're applying. What statute has asked us to do in this rulemaking is to apply a no net negative adverse cumulative impact standard to disproportionately impacted communities. And I think as we were evaluating the application of the social cost of carbon and understanding that we're required to apply a mitigation hierarchy that pretty clearly looks at a more finite area of evaluation. How does this even get contemplated in a decision-making process that includes a mitigation hierarchy?
Mr. Messner, I think let me, and I'll sort of take this in pieces. So, in that evaluation of a thorough cumulative impact analysis, right? There are multiple factors, and some that I touched upon in my testimony, impacts on wildlife, odor, all of these various factors. Climate is also one of the factors that is directed to be considered as part of that analysis that you're talking about in the potential permitting of a Class 6 well. The impact of climate can be determined through the use of the social cost of carbon. So that impact on climate that is called for as part of that analysis, that comprehensive analysis that we're discussing here, that can be determined as part of a more comprehensive cumulative impacts analysis. So the impact on climate is one of the many factors that goes into that analysis. But we're saying the best tool for evaluating that impact on climate is the social cost of carbon. So on that one metric, the use of the social cost of carbon is the appropriate mix. That, as we've said, is potentially broader. It brings in benefits that are beyond that local community. But the best way to evaluate climate is to use the social cost of carbon. And that really is what we're trying to say there in that context of a broader impact analysis.
But again, I'm trying to figure out how the applicability of that, when at least my understanding of the social cost of carbon, and I'm no expert at this by any means, but if I look at definitions across the board on the social cost of carbon, it's indicated as primarily, an economic tool. And so that's where I'm struggling a little bit, as we look at evaluating potential beneficial and adverse impacts to public health and the environment. And so please correct me if I'm wrong, but that's in my research that and looking at different definitions of social cost of carbon. My understanding is that it's primarily an economic instrument, but maybe I'm misunderstanding.
I wouldn't disagree other than to say, I think really what it encompasses or what it's attempting to encompass is really a standardized impact. I would describe it as an impact that tries to capture the benefits or harms to climate related to 1 ton of CO2. There are many impacts. There are communities in Colorado, mountain communities that are susceptible to catastrophic wildfire. There are communities that are reliant on snowmelt for spring runoff. All these things, there are all these different impacts that climate change can have, and trying to sort of bring that into one impact, if you will. That's what the social cost of carbon represents. So it is a number, but it is really intended to be an impact, if you will, or to encompass that impact. And that impact is set out as the social cost of carbon that increases year over year, recognizing as more and more greenhouse gases get emitted to the atmosphere, there's more and more harm. So the social cost of carbon for today is lower than what it would be set for the future. But that evaluation is really just again, I would say really intended to be a metric of impacts more than a traditional sort of economic analysis tool.
Okay, and that's helpful. Again, I'm just trying to understand the perspective here, and so I don't have a problem with the social cost of carbon. I do want to make sure that the rules, we're able to actually apply the rules properly with the tools available. And so my last question along that line is, inherently, as we evaluate cumulative impacts, and in particular, the statutorily directed no net negative adverse cumulative impacts to disproportionately impacted community that we're required to do as part of this rulemaking, a lot of emissions factors would be considered as beneficial or adverse impacts. And so I guess my question is if we're already looking at emissions profiles and emissions elements as part of that evaluation for a cumulative impact and looking at that no net negative adverse impact standard, is that not already captured from a climate perspective by looking at the specific point sources or the beneficial emissions profiles that may be incorporated in a Class 6 injection well project, versus any adverse emissions that may be associated with the construction or operation of that site?
Well, I would distinguish maybe between the types of emissions and based on the type of pollutants, Commissioner, right? There are pollutants that have a harmful local impact, but that don't have necessarily the global impact that our greenhouse gas emissions would. So I think it is appropriate to segregate those out and look at the impact of greenhouse gas emissions, in this case CO2, on the climate, as opposed to potentially looking at other pollutants that would have more harm locally.
Okay, thank you.
Ms. Torrenson or Mr. Tour, I see both of you have visualized. Did you want to provide any additional perspective to any of the questions that have been launched so far?
Thank you. Will Tour, Executive Director of the Energy Office. And just one additional comment in terms of the social cost of carbon being used as a metric for climate damages. In many ways, I would describe that as very similar, for instance, to the way that the EPA COBRA tool can be used for monetizing the impacts of other pollutants on public health. So as Clay said, I just wanted to really reemphasize the notion that while the social cost of carbon is shown as a dollar value, it really is based upon damages that take place to the environment and to human health associated with greenhouse gas emissions. And while it is not a perfect metric, it's probably the best metric that is available for really considering the climate benefits of carbon sequestration. And we think it is one important metric to use in your broad evaluation of cumulative impacts.
Mr. Tour, I may be the only one that doesn't know this, but what's the COBRA tool?
Oh, it is essentially a tool for monetizing the impacts of a variety of types of pollution, and essentially, often used in cost-benefit analysis in order to have some common metric to be used among multiple different types of impacts. Okay. And not suggesting that that's a tool that needs to be used, but just wanted to essentially make the point that it is relatively common to build tools that may report out in a dollar value, but are really based upon environmental harm.
Okay. Commissioners, further questions for the panel? All right. Seeing no further questions, Mr. Clark, I'll have Hearings Manager Thomas reach out to you to elaborate on the correct method for getting the written statement into the record. And so we want to thank our sister agencies for following the work that we're doing and for providing perspective to us so that we get our regs in the correct spot for the state of Colorado. We'll let the panel non-visualize and bring it back to the commission for deliberations on next steps. Commissioners, we've now heard from our sister agencies on the social cost of carbon. We still have before us the, I suppose we sort of said no to Wild Earth Guardians, Green Latinos, and 350 Colorado with regard to their objection to request to reopen, because we did reopen. But they do have in place a second request that if we did reopen, they would like an opportunity to respond. We have the CCS group in the chamber also asking for a chance to respond. Their suggestion was a written response by Friday of no more than 5 pages. My meanderings on this are, one, this does not impact, or the request does not impact the rules that we're contemplating adopting, but it does impact the statement of basis and purpose, which is an important document that helps to define what the rules mean. I believe that what we heard this morning is substantial enough that I, at least as one commissioner, would like to hear from any party that wants to provide us with perspective on this. I think that since we're having this filed in writing, doing more than just giving a day for folks to read that and then come back to us and speak to us, I guess I'm of the perspective that a slight written proceedings filed by Friday makes some sense. I did check with the hearings officer, and all 5 of us or 6 of us are available Monday afternoon for a final continued piece that would give us a chance to read the written documents on Friday. I would suggest 5 pages or less by noon Friday from the parties. And then we could take up this matter on Monday at 1 p.m. I'm not suggesting we can't go forward this morning with a continued review of the red line and any other matter that the commissioners want to see, so that we really are just focused on the social cost of carbon piece on Monday. That could be a fairly short meeting. Those are my musings on procedural matters. Would love to hear from other commissioners. Commissioner Messmer?
Thank you, Mr. Chair. Yeah, I'm struggling with this one a little bit because um I understand and appreciate the importance of social cost of carbon to um lots of different applications and agency actions and um I think there's lots of opportunities for that utilization. I think that like I think you could probably understand from my questions that this commission was, in my opinion, tasked by statute to utilize a pretty finite lens in determining the no net negative cumulative impacts to disproportionately impacted communities, and that lens being specific to public health and the environment, as looking at beneficial and adverse cumulative impacts. And understanding that we just went through a cumulative impacts rulemaking and determined what was necessary to be included in the rules to evaluate cumulative impacts. What we're being asked to do in this rulemaking is more specific than that. We're not looking to revisit, how we evaluate cumulative impacts generally, but rather how we're looking at a no net adverse impact standard to disproportionately impacted communities. And so I want to be really careful with how we handle this, that we're not re-looking at how the social cost of carbon is considered throughout ECMC's rules. And so to me, that's a little bit of a concern here. I do think that there are elements, environmental and public health elements associated with some evaluation of social cost of carbon that even as the rules as drafted could be utilized in a proposal for evaluation of no net negative cumulative adverse impact to disproportionately impacted communities. I think that the current draft rules and statement of basis and purpose already capture that. I don't know as it's a prohibition, at least the way I understood it, to the utilization of the social cost of carbon, but at an acknowledgement that public health and the environment needs to be the area of focus, and not the beneficial and adverse economic impact associated with any project, which the act actually does not allow us to consider holistically throughout our rules. And so anyway, having said that, if there is going to be this significant contemplation of the social cost of carbon within our cumulative impacts rules, as well as this Class 6 rulemaking, I absolutely want to hear from parties. I want to give them time to provide us input and to look at, to better understand their perspectives. And so I fully understand it. But I also think that with the CDPHE and the Energy Office's testimony on the record, our consideration of that and understanding that, in fact, the social cost of carbon from an environmental and public health standpoint could be utilized in determining a no net negative cumulative impacts analysis and a no net negative cumulative impacts analysis in disproportionately impacted communities, which I believe the rules already allow and the statement of basis and purpose already allows. I'm not sure what change really needs to happen. And so to me, the cleanest thing would be to do nothing but acknowledge the record here today and understanding how the social cost of carbon should be utilized and not have to go through what could be a pretty complicated set of response statements to this topic. So that's I can go either way. I'm not hung up one way or the other, but the simplicity of it would be stay the way it is, acknowledge the record, and continue forward with our final decisions today.
Okay, so to summarize, you would just not follow what I was suggesting and just move forward today. Appreciate the thoughts, Commissioner Messner.
Thanks.
Other commissioners with thoughts? Commissioner Oath, then Commissioner Ackerman.
Thanks. I guess just briefly, I would be in favor of hearing further from the other parties on this before making a decision on whether to leave things as they are or change them in some way in the statement of basis and purpose. So I'd be in favor of allowing some time for response and then having some further deliberations.
Okay, thanks. Commissioner Ackerman?
Thank you. And, philosophically, my thought process has been similar to Commissioner Messner's just articulated process in leaving, the record, leaving certainly the consideration of social cost of carbon open in many instances in our record. That said, I completely agree with Commissioner Oath and you, Mr. Chair. I think that since we've opened this door and allowed for that comment by the agencies, I think we need to listen to what the responses might be prior to further consideration.
Okay, thanks, Commissioner Ackerman. Commissioner Cross?
Thank you, Mr. Chair. I'll say when it comes to opening the record back up, I do think we need to give the other parties a chance to respond to the comments that were made. I believe this can effectively be done in a written statement, and I think that it can be much more succinct in a written statement than trying to open it back up to testimony being provided orally. I agree with what Commissioner Messner said as well. I think this is a tough one where we're trying to balance what the statute says with respect to limiting cumulative impact analysis to the public health and environmental beneficial impacts with something that does have economic impacts as well as considerations of climate change and some public health impacts, et cetera, in it. So I'll just say that I do think that we should open it up to written comments. I don't know that we need to bring the parties back to provide comments. I'd be fine with just something written. But I think that this goes back to some of our discussion last week of we can properly look through what's provided to us and the different things and assess it under the guidelines provided to us by the legislative mandate. And I think that we can put something in the statement of basis and purpose about how that can be done. But I do ultimately think that this is something that's best left to the discretion of the commissioners with respect to meeting our legislative mandate.
Appreciate that, Commissioner Cross. I tend to agree. I don't like when we box ourselves with rules or SBP language and appreciate leaving it to the commission's discretion. I think there could be an argument that the social cost of carbon is sort of putting a economic amount relative to even public health and environment. So there is an argument that it's not totally prohibited. But I really want to hear from parties on this. So I think a majority of commissioners are okay with us entertaining a motion to allow additional party perspective on this complex topic, no more than 5 pages, due in writing by Friday at noon. That's Friday the 13th. Oh, lovely. So I would so move. Although before I do that, I see that Director Murphy has her hand raised.
Thank you, Chair. The one thing that I wanted to offer, I think to help facilitate consideration by both the commission and the parties, is that staff, in concert with having Mr. Clark's statement put into a PDF form and put into the record, could also suggest a narrow change to the SBP that might help shape party comments or reflection. It may be easier to respond to something specific is what I'm trying to get to. If that would be helpful, happy to get that done yet today as well.
Yeah, no, I think that would be helpful. I don't know that it needs to be done yet today. And if we are going to go down the road of having written filings, staff may want to look at the filings too. But maybe if following the filings, staff could put something together and get it into the record, by close of business Friday, then the commissioners would have the weekend to take a look at whatever's been filed. Is that fair?
I would suggest that we do try to get something in today that is kind of narrow, and then digest the filings that I think are coming in on Friday and see if we would want to be prepared to support you all as you evaluate further or additional changes on Monday, if that works.
And both always works.
Guess I should apologize to everybody for all the volunteering I just did, but thank you. We want to
It's
make
your
sure
fault.
you're supported.
All right. AG Davenport is now visualized, so he may have something to weigh in on.
Well, thanks, Chair. I just wanted to check in on a few things in regard to what you were contemplating. It sounded to me, without wanting to put words in your mouth, that you were effectively proposing granting the non-objection, the request of the parties who filed the non-objection and an opportunity to respond in writing. And there were two additional pieces that I wanted to mention. One is that these written responses, and just to be clear about it, is in lieu of the proposed oral responses that were
That's
proposed
correct.
by.
Or at least that's what I'm thinking. Yes.
And the other one is the proposal did include the provision that the written responses would be double spaced, and that of course significantly alters the amount of information that could go into 5 pages. And so I wanted to raise that and see what the commission's or your interest in including a specific requirement that pleadings be double spaced.
Yeah, 5 pages double spaced works for me. I think people ought to be able to get their point across on this narrow yet complex issue in that amount of acreage.
Okay, thank you. I'm done.
Any responses to any of that from any of the commissioners? Commissioner Messmer?
Thanks. I'm happy to hear from folks. I do want to make that clear. I made an alternative suggestion. Should we want to consider something that may not require this? But happy to hear from folks. And I do think that the specificity that you laid out as to what needs to be submitted is a good approach. So thank you.
Yeah, no, I appreciate the clarification, Commissioner Messmer. All right, I will move that we, and help me, AG Davenport, but move that we allow the parties to file a 5-page written double-spaced response on the issues that are generated from the CDPHE and CEO statement on the record today relevant to social cost of carbon and our utilization or non-utilization of same in our rules and or as articulated in the SBP to be filed by noon on Friday, period, hard stop. And then we will, we'll see if that suffices for that motion. AG Davenport?
Just to be perfectly clear on the record, thanks, Chair. That's this Friday, December 13th, noon on that day is the deadline.
That is correct.
Okay.
Do we have a second?
Second.
Do we have further discussion on the pending motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Okay, that motion carries. I do believe we ought to make utilization of our time this morning to review the red line draft submitted by staff and or any other particular elements of the rulemaking that a commissioner desires to deliberate on. It's 10:09. Let's take a 10-minute break and return at 10:19, and then we'll take that matter up next. Welcome back, commissioners. The Energy and Carbon Management Commission. It is 10:19, and we're taking up docket 241-000-246, the Class 6 rulemaking. Commissioners, staff filed red lines to the November 20th rules a couple days ago, and we've all had a chance to take a look at those. I wonder if, so right now the record remains, well, no, the record is open because we reopened it. So that procedural matter is taken care of. At this point, we have an opportunity to talk amongst ourselves on the red lines, to deliberate on the red lines, to ask questions of staff. I know that AG Mercer has both the red line to the SBP and the red line to the rules ready to share if we have questions. To get started, I thought staff did an excellent job on articulating into the red lines the deliberative thoughts that we had expressed to staff. So I'm pretty good with the red lines. I do have one additional issue I wanted to speak about that doesn't have to do with the red lines, but let's talk about the red lines first. Does any commissioner have questions, desire to deliberate on the red lines, desire to ask questions of staff on the red lines? Seeing none, Commissioner Messner?
Well, I mean, I'll just state that I think that the red lines were really well done. I think that they captured our voice, and ultimately, I believe that the draft rules that we have before us, do the things that they need to do, which is capture the elements necessary to meet the requirements of the EPA for gaining primacy. Apply the clear direction. They apply the clear direction provided by this commission, by the legislature, and Senate Bill 2316 and HB 241346. I think they comply with the Federal Safe Water Drinking Act, and have incorporated much of the feedback provided by stakeholders to achieve a comprehensive regulatory regime for Class 6 UIC wells and create sequestration opportunities for Colorado. I don't have a lot of suggestions or any suggestions for the rules. I think that, in any rulemaking, and in this one in particular, the amount of work that's been done between stakeholders and staff over many, many months has been significant. I think, what we have before us through our process was well vetted. I don't think all stakeholders got what they want, but I also think a lot of stakeholder feedback was incorporated into the rules. And so I'm comfortable with the rules that are presented here without any changes. So those are my thoughts.
Thanks for the thoughts. Other commissioners on the red lines? Commissioner Ackerman?
Thank you, Mr. Chair. I actually did just have one suggestion for consideration, and I agree with Commissioner Messner's comments and appreciate him stating what he did. This was with regard to the Bruneau area. I believe that when we discussed the Bruneau area, we suggested that, we directed that that there wouldn't be a requirement for consultation, but rather that it was an invitation for participation in the public process. And we also directed that that wasn't intended to imply any special legal standing in that process. I didn't see any notes on the legal standing in the basis and purpose statement on that, but rather just states that they'll have the opportunity to engage with the commission on the development plan by participating in the associated commission hearing process. It would make some sense to me to directly state that that invitation isn't intended to imply any special legal standing with regard to that associated hearing process.
Appreciate that catch. I would agree with you, Commissioner Ackerman.
And that's all I have. Thanks, Mr. Chair.
Anything further on the red line draft before us? The one area I wanted to bring up, and I may have brought this up before or not, and this is an area of substance, and we're still in deliberative stage, so I think it's appropriate. And this has to do with stratigraphic or test wells. Right now we have a standing order that stratigraphic wells or test wells are something that can occur administratively. I do not believe that stratigraphic wells or test wells need a full commission hearing, need a full cumulative impacts analysis. They do not trigger the same sorts of things, and they are an important tool for operators that desire to think about CCS in our state to be able to utilize in a sort of administrative fashion. I think our standing order is working, and I would suggest, at least as one commissioner, that we have staff adjust the rules so that stratigraphic or test wells can be something that's done administratively. Of course, if those wells then become part of a CCS project, that would be part of a full-blown commission hearing with cumulative impacts analysis, et cetera, all around it. So that's one final piece that's been keeping me awake at night. I desire for Colorado to be open for business with regard to CCS. And from everything I've heard from operators that potentially want to work in our state, having an ability to administratively scientifically test whether CCS could work makes some sense and doesn't need a full-blown analysis. So that's one final piece of consideration that I throw out to my fellow commissioners for consideration this morning. If I can generate consensus on that, I would then direct staff to maybe think about that and get back to us on that point. Commissioner Cross.
I wholeheartedly agree with that point.
Any other commissioners desiring to weigh in? Commissioner Messer?
Mr. Chair, I'm just going back to look at the rules, and so I don't know if I'm ready to answer that question right now. I'd like a second to look at them and just better understand your request before I can have an opinion on that.
AAG Mercer, I see that you've, or AAG Mercer Gelman, I see that you have visualized. Could you provide some perspective off the cuff to all of the commissioners relevant to how the rules address stratigraphic wells at this point in time?
Thank you, Mr. Chair. Yes, I was hoping to provide that and also get maybe some clarification on your statement. Right now, stratigraphic and monitoring wells would be permitted under Rule 1403, which does set forth an administrative review and approval process. It's modeled after the standing order that the commission currently uses to permit stratigraphic wells. So it's staff's position that strat wells and monitoring wells are already under the draft rules subject to administrative approval, and a full hearing would only be required if an operator later desires to convert those wells to Class 6 wells. So happy to answer any more detailed questions, or if there are specific aspects of the administrative review set forth under 1403 that the commission would like to adjust. Of course, we're all ears.
Great, and maybe I had missed it. I wanted to make sure that it was an administrative process, and I guess I had read it that maybe it wasn't, but you're saying that it is an administrative process at this point?
It is an administrative process, yes. It does require things like a cumulative impacts analysis and alternative location analysis and some of the more robust aspects of the permit application materials. But strat wells and monitoring wells are not required to go before the commission as for a hearing. Rather, they would be administratively approved.
Yeah, and maybe that's where I was having some concerns. Again, I'm just one commissioner. I do not believe that the full-on robust cumulative impacts analysis is necessary for a stratigraphic or test well. I think that is a lot of work that is, again, it's really needed when we're getting into a CCS project, but I'm not sure that amount of work is necessary for a test well. And so I guess maybe I would suggest that 1403 be narrowed a bit if we're going to have a rule around it so that it really is more along the lines of the standing order. So I would adjust my comments in that regard, AG Mercer Gelman. Commissioner Cross.
Thank you, Mr. Chair, and I'm fine with that as well. And I think it's also important to note this is what we decided to do with the geothermal as well, and trying to make sure it was encouraged.
Commissioner Oath.
Thanks. I guess I have a question that's probably a staff question. So if I'm understanding what you're suggesting, Mr. Chair, it's that so it sounds like the current rules, and I'm just looking through them as well, do allow for an administrative process for stratigraphic wells and monitoring wells, but do require cumulative impact analysis and alternative location analysis. And I think what you're saying is to propose that the latter two components of that not be required at the stage of this. And so as I'm thinking about it, I think that to me, a large part of the importance of those analyses are about surface impacts during drilling for Class 6 wells. And so I guess the question to staff is, can you enlighten me at least about what differences there are in terms of potential surface impacts during drilling of stratigraphic and monitoring wells, and how that's different from Class 6 wells?
AG Mercer.
Thank you, and thank you, Commissioner Oath. I would refer this question to Mike Rigby or Mark Sealy if one of them are available. And I see Mike.
Mr. Rigby.
Thanks, Commissioners. From my perspective, a lot of the drilling impacts associated with science wells, at least the ones very particular to the drilling phase, will be somewhat similar. They'll be drilling to a similar depth because they're testing the intervals that they'd be proposing for, or likely they'd be testing the intervals they'd be proposing for the Class 6 well. So I offhand here, I can't really say the impacts would be, at least in the very particular part of the drilling of the well, would be much different.
Commissioner Messmer.
Thanks, Mr. Chair. So I appreciate AAG Mercer Gelman explaining that it was administrative approval. That was my thought, and so I was scratching my head there for a second, thinking that I misunderstood that, and that the commission hearing happens when and if that science well is going to be converted into a formal Class 6 well. And so I think that's the way I understood it. I do think that there are some streamlined elements associated with Rule 1403 in order to make it easier for those science wells to occur. But I also think that there are impacts associated with those science wells, and that while some streamlined elements that are not necessary as part of the application process for those, even with an administrative approval, are not required as part of 1403 for science wells, there are certain things that are required that I believe are important as far as considering where these things are going to be sited and the potential surface impacts associated with those that we're required to evaluate, whether we're looking at applications administratively or in front of the commission. And so I do think Rule 1403 as written creates that balance, I think, pretty well to both allow those science wells to happen, but also ensure that they're sited in areas that are going to avoid, minimize, or mitigate potential impacts, and also create situations where those science wells may very well be able to be converted into Class 6 injection wells, which in many situations, in my understanding, would be the most economic opportunity for those, the utilization of those in the future. And if they're already sited appropriately, then they wouldn't have to duplicate the efforts of creating a new Class 6 wellbore in many situations, if they do want to ultimately convert that into an injection well. So I would support leaving it as is myself. Thank you.
I'm appreciate the discussion, and thanks everybody for letting me raise it. And I still believe that the full-blown cumulative impacts analysis is not necessary at that point in time. I think the operator is going to know full well that if they are successful, they're going to have to do that when they propose the full-blown Class CCUS project down the road. And so it's going to happen. It's just going to happen at a later time. And I'm still in favor of streamlining in a safe and protective manner the concept of stratigraphic or test wells, because I see that as a condition precedent to whether this is going to happen or not. And I may be in the minority on it, but those are still my thoughts on that point. Others desiring to weigh in? Commissioner Oath?
Thanks, Mr. Chair. Not thoughts, more still just trying to understand how this would play out. So with your thinking, and understanding the importance of being able to do exploration and some science, right? And that's different than committing to a location. But I guess just trying to understand the way it would work, seems like if we were to not be doing requiring an ALA and the cumulative impact analysis at the time of the science well drilling, then when there is a desire to convert it, if they're assessing the cumulative impact and the location, the drilling, if it's near, a sensitive area or people or something, that would lead either the operator or us to desire a different location or think a different location made sense in the mitigation hierarchy. I guess I'm struggling with that. I don't know if you have any any thoughts on that, but just kind of sharing my sort of thinking as
yeah, no, I appreciate that. And maybe I would ask Mr. Rigby to help us understand sort of the process. But, in my naive understanding of this, and I'm no expert, the science well or test well is checking an area for whether it is going to be amenable to a future project. I would assume that does not at all times mean that the only location for the project wells is the actual same well as the science well. Is that right, Mr. Rigby?
Thanks, Chair Robbins. That's correct that that's not the intention all the time. That is the intention sometimes. So there are different strategies that different companies take in this process. There are companies that have drilled science wells, then converted them to, for instance, a monitoring well rather than the Class 6 well. And then they permitted a separate Class 6 well in a different place, obviously nearby, very nearby the science well, but not the exact same place. There are other companies who have the full intention of converting the science well, and they case it to Class 6 standards, spending extra money on the casing for those science wells with the intent to convert them. But that is not always the case. It can be the case. And I do think in those situations, the operator would be looking at the surroundings to ensure that their strategies of converting a science well would be a viable pathway. However, there's nothing to say that is required through like the science well process. It'd be more of just something to be prudent about if you were intending to spend more money on the construction of the wellbore to convert it for Class 6 use to make sure it can be sited there. That said, all options are kind of on the table when progressing through these projects, from using the science well to drilling a separate well after the science well.
And I appreciate the explanation. And, because we're contemplating theories or hypotheticals, me still is of the opinion that allowing for flexibility and allowing the science or test well to be done in a manner that, again, remains protective, but is administrative and doesn't necessarily have to involve the cumulative impacts of the ALA, because it may end up being a monitoring well or because it may end up being nothing. I still think that is in concert with one of the things that I think we're supposed to be doing, which is creating an open for business Colorado for CCS. And so I would still be in favor of amending 1403 to remove out those two elements. Commissioner Ackerman?
Thank you, Mr. Chair. And I do have one question for Mr. Rigby. In the situation in which a test well is drilled, and as the chair noted, if further action is taken to develop, it's entirely possible or procedural that then we would do a cumulative impacts analysis later down the road. Would that cumulative impacts analysis then go back retroactively and include the impacts of the drilling of the stratigraphic well also? Do you know that offhand?
Mr. Rigby or AAG Mercer-Gilman?
I may defer to AAG Mercer here.
Thank you. So, yes, so that was one issue that was raised by some parties and trying to make sure we were, staff had the ability to get the information and the analysis needed without requiring duplicative cumulative impacts analysis. So the way the rules are currently structured, the operator would be required to do a cumulative impacts analysis for the stratigraphic or monitoring well. And then they would still need to satisfy the cumulative impacts analysis requirement at the Class 6 well permitting stage. But we added language based on the commission's instructions to allow operators to submit substantially equivalent information or analysis that they submitted previously for the test well. So I would imagine that most operators would sort of reuse the cumulative impacts analysis that they performed on the strat well and then add to it as needed to include any other impacts from the ongoing operation of a Class 6 well. Does that answer your question?
It's helpful, but I'll follow up. And I apologize again for putting you on the spot. I appreciate how prepared you always are. But is the inverse true then if we did implement what the chair is asking here? Would they still have a requirement then in the follow-up cumulative impacts to go back and retroactively consider the stratigraphic well impacts of drilling also? Does that question make sense to you?
It does, and it's a good question that I think we'd want probably want clarification from the commission on what you would like to happen there. I think just off the cuff, if the well is already drilled, it wouldn't necessarily make sense or be required that those impacts be included in a subsequent cumulative impacts analysis. That said, if the commission wants that, we could make that clear in rule language or in the SVP.
Thank you, AAG Mercer-Gilman. And then I guess just one comment, Mr. Chair, along the lines with your comment in that historically our approach to stratigraphic wells has been one of still, as you noted, significant restriction and significant rules around those. The intent has been to facilitate opportunities to understand if development can occur, and hence our approach to, as you stated, kind of be open for business while still protective, and then adding additional protections down the road. I philosophically am aligned with that approach. I was on geothermal. I am on CCS as well. I do think it would be prudent to somehow consider, if we're talking about, a deferral of cumulative impacts analysis to later down the road, at least have a discussion of how we would address the cumulative impacts or wrap the cumulative impacts of the stratigraphic well into that later assessment.
I appreciate the identification of that issue, and I'm in alignment with your thoughts, Commissioner Ackerman. So I would, again, defer cumulative impacts and ALA out of 1403 administrative approvals, but down the road, if that's turned into a CCS project, then bringing those elements in, and would appreciate AAG Mercer-Gilman's ability to weave that concept into either the rule or the SBP as well. Commissioner Messner?
Thanks. So I think there is an intent here to, make it open for business for carbon sequestration. I don't think the existing rules. And so here's where I'm struggling a little bit. In an attempt to do that, I think that there has to be some economic efficiencies built into like what we're considering here. My biggest concern here is that we're going to ask operators administratively to not evaluate certain things for sequestration wells. Those sequestration wells will happen. And I understand that there's protections in there inherent with our requirement to have, 2,000-foot setbacks and, other pieces that are part of this, and that those would apply to science wells. But in order to make sure that operators don't get themselves in a bind by not requiring some of this stuff up front. And so I'm not going to get hung up on this, but if we don't require it up front, they do their science well, they pick a location, they've invested significant amount of money in the science well, and then they go and want to do the injection well associated with it, turn the science well into a monitoring well, do another well. But then as they do the cumulative impacts analysis or the alternative location analysis, there's problems that jump up that maybe doesn't allow for that class 6 injection well to happen. To me, that is more problematic than perhaps doing a little bit of analysis on the front end. And so really, from a regulatory standpoint, to make it so that it is really clear, what ultimately may need to happen should their science well be successful from a siting standpoint, may save the operators a lot more money and time by doing a little more analysis, even with an administrative approval. So like I said, making sure that there's enough streamline to encourage those science wells, but with enough documentation or analysis to make sure that 3 years down the road, when they really do want to convert not necessarily the science well, but the general area or location into a class 6 injection well, that they don't have to abandon that site, because ultimately when they do the cumulative impacts analysis or the alternative location analysis or the other elements of the class 6 permit, that they find that area is not suitable. And so that's my only concern. So I'm not trying to put roadblocks up, but rather to make a clear, certain regulatory regime for these operations. And so, does a cumulative impacts analysis need to happen as part of the stratigraphic well, or an alternative location analysis? Maybe it doesn't. I think that the 2,000-foot hard setback on these, does already create some considerations for alternative location for at least proximity to humans. I don't know about the other elements that need to be evaluated. But I just don't want to see an operator spend a ton of money to do a science well, only to find that once they do their application for the full-blown class 6 injection well, that the site may not be appropriate based on the additional information that would be required at that stage. And so that's my concern, not trying to create any roadblocks.
Now, I appreciate the thoughts on I sort of my thinking on this is, the point is for the operator to make that call, not for us to make the call. And I think removing cumulative impacts in the ALA from science wells could at times indicate to operators and others that Colorado is open for business, because those things are not necessary for what is at the moment primarily or a science well or a test well. And so I still am of the opinion, if an operator is thinking they're going to do a science well or a test well, and they know darn well down the road that they're planning on turning that into a CCS project, that they're going to have to do cumulative impacts analysis and an ALA, despite the fact that things are already drilled, well, that's on them. I'm just trying to put all the onus on the operator and not the onus on us. And I'm trying to remove perceived or for real roadblocks for our state in the ability for operators to come and potentially think about doing things in our state as opposed to Wyoming or Nebraska or someplace else. That's my main point here. Others with further thoughts on this topic? I don't mean to run this into the ground. All right. I don't know where to go. You've heard me. We've heard some of the other commissioners. I don't know. AG Mercer Gilman, help me. I'm struggling.
Thank you, Mr. Chair. I would say for staff to take some action on this feedback, we would need a vote or at least sort of a straw poll indicating that a majority of commissioners want to see changes to this rule. And to sort of get the more specific instruction, I think there are really three elements in 1403 that you're talking about. There's the alternative location analysis, the cumulative impacts analysis, which is the sort of full-blown Rule 315, I believe, narrative analysis of various impacts. And then there's the Form 50B, which is the sort of numeric data-driven form that reports on cumulative impacts. I would note that in Rule 1403 B4, the requirement is for a modified Form 50B that includes estimates of impacts resulting from location and access road construction, well drilling, testing, and scientific data gathering activities. So really what we would need instruction on is whether the commission desires to remove the ALA, the CIA, or the modified Form 50B, or any combination of those. And we'd need that direction to come from a majority of the commissioners.
No, thank you. You always do an excellent job, as Commissioner Ackerman pointed out, of being ready to help us move forward on that. With that suggestion, I'd like to take a straw poll on the concept of removing all three of the elements from 1403, which does indeed ensure protections for purely science or test wells. And then if they come back and they want to alter that, then they're going to need to go back through and do a full-blown cumulative impacts analysis and ALA, and all that's going to be in line with Commissioner Ackerman's thoughts that would include the impacts of the actual well as already drilled. Commissioner Oath?
Thanks, Mr. Chair. I know I appreciate you laying that out, and know that you want to move to a straw poll, and I think that makes sense. I think before we do that, I guess I just wanted to articulate better my thinking on this, and I think based on the comments so far, a sense of where our straw poll is likely going to go will probably leave me in the minority. So I just wanted to explain kind of my thinking here, which is just, I guess I'm absolutely want to make sure we're developing a framework that it leaves Colorado open to business. And I understand that there's a difference between, science wells and full-blown commitment to the Class 6 well. I guess I'm struggling to see how looking at cumulative impacts and ALA after the fact will avoid potential impacts, since the impacts are during the drilling phase. So that's where I think where my concern is with doing this on the back end, but do very much appreciate, for those who are in support of this, having that, looking at the, retroactively looking at the impacts of drilling at the time of conversion to Class 6, I think is, at least I think that remains important to be part of the consideration. I just think it will be challenging to do so because those will have already occurred.
Yeah, I appreciate those thoughts. Other commissioners with thoughts before we take the straw poll? All right. Sensing that this is not going to be unanimous, which is fine. That's why we're a commission. I'm in favor of the straw poll. Commissioner Oath, I'm just going to call on people just to sort of say what they want to do. I think you're not in favor. Is that right?
That's right.
Okay. Commissioner Cross?
In favor.
Commissioner Messner?
Not in favor.
Commissioner Ackerman?
Thanks, Mr. Chair. And just to be clear, the straw poll is to remove those three elements, correct?
That's correct.
As we do for other stratigraphic wells in the state.
Yes.
Yeah, I'm in favor.
Okay. AG Mercer-Gelman, I believe you've got direction from a majority of the commissioners. We obviously would like to see the language, and so we'll wait and allow you guys to do yet another fantastic job of trying to capture the disparate points as made by the commission.
Thank you, Mr. Chair. We'll make those changes and make sure that a new red line is available prior to the commission reconvening on, I believe, Monday is the plan. So we'll get that by Friday.
Okay. And I think back to the red lines, we're all comfortable with the red lines. Is anybody not comfortable with the red lines? And excellent work by staff to capture the deliberative thoughts in the form of rules. So I think what we can do is adopt the red lines into the rule draft and then add in this last straw poll motion, number one. Number two, we've directed via motion any party that's interested in weighing in on the social cost of carbon to do so by noon on Friday in 5 pages of double-spaced writings. And staff is going to provide us with its thoughts on the SBP on social cost of carbon, I think yet again today, and then maybe again on Friday. Commissioners, you'll need to take a little bit of time, maybe Monday morning, to take a look at anything that's been filed. And then we are to reconvene on docket 241-000-246 at 1 p.m. on Monday. Monday being the 16th. Did I miss anything, Commissioner Messner?
Yeah, I might suggest that we, like with this, leave the ability to modify the rules until after we hear party statements, because I have no idea what parties are going to say here. It's a little unclear to me, what the path would be for incorporation of the party's thoughts on Monday. And so while I'm comfortable with the rules as they're drafted here today, if we're opening kind of the door for party comments, I think we have to be able to modify the rules based on some of those comments if we feel like it's necessary or not.
I agree. I think we're just waiting to hear from parties on that topic, and we'll have the ability on Monday to deliberate on it and figure out, where we want to go, if anywhere.
Well, I thought you said we were going to adopt the rules today, and so
no. I'm sorry if I implied that we're adopting rules. I don't. I think what I was saying is that we're comfortable with the rules that were redlined, and go ahead and you can allow those red lines to become rules, and then we're waiting to determine what we're going to do with regard to the entire rule set, including the social cost of carbon and including the straw poll thing on Monday. So yeah, no motion to adopt anything today. I was just moving away from a red line into an actual clean version. Anything else? All right. Well, to the 61 participants, thanks for watching the sausage making today. We will adjourn and return on Monday the 16th at 1 p.m. for final consideration of the Class 6 rulemaking. I think that's it. Everybody have a good weekend.